Hello, and welcome to Raising the Bar with the MBBA. I'm Adeola Adejobi.
And I'm Jason Clark, president of the Metropolitan Black Bar Association. The MBBA is the largest association of predominantly African-American attorneys in New York. Our mission is to advance equality in the pursuit of justice, assist in the professional development of our members, and address legal issues affecting New Yorkers. The goal of Raising the Bar with the MBBA is to foster a substantive conversation about justice issues in our community, while also trying to identify some solutions in the process.
Today, we are going to discuss the Raising the Age Act. Our guests today include New York Supreme Court Justice Guy Mitchell and attorney and MBBA member Rasheim Donaldson. Welcome, and thank you for joining us.
Thanks for having us.
Thanks for having me.
So let's dive into it. So in April 2017, the Raising the Age Act was passed. And before then, if you were 16 or 17, you were still prosecuted as an adult. Rasheim, can you tell us a little bit about the Raise the Age Act and what that means for New Yorkers?
Sure. So Raise the Age effectively changed the way the criminal justice system viewed young people, and it particularly affects 16 and 17-year-olds because until that legislation went into effect in October 2018 for 16-year-olds, they could be prosecuted as adults. And October 2019, around 6 months from now, the 17-year-olds will change the way they're interacting with the system. So essentially, many cases will be removed from the criminal justice system for adults to family court, where those records are sealed. And it has huge ramifications for a young person in their trajectory.
So another issue that maybe some of our viewers don't know about is, criminal responsibility. Why is Raise the Age of and criminal responsibility an important issue?
This is a huge issue because young people, and research has supported this, that young people don't think the same way as adults. Adolescent minds are still developing, and science supports that the human brain isn't fully developed until around 25 years old. Right. Therefore, young people younger than 18 are obviously much more likely to commit irrational acts, not use reason and logic, not really think through the consequences of things. And when you look back at the justifications for punishment, these things don't really apply to young people if they aren't fully appreciating the consequences or what could happen as a result of a poorly made decision. Mm-hmm. So it really changes the way we view this. And the family court system focuses on rehabilitation. So a lot of these services that will be available to young people will be rehabilitative and restorative and more holistic as opposed to punitive.
Mm-hmm. Okay. Great. And so what are some of the practical changes as a result of Raise the Age?
Sure. So as we mentioned, the 16 and 17-year-olds, they will have the opportunity to have many cases removed to family court. When 16 and 17-year-olds get arrested, their parents have to be notified. When they give statements, in other words, when they're interrogated by the police, their parents need to be notified about that. They also, if they are detained before trial or after an arrest, they will not be housed with adults because young people are much more vulnerable to sexual assaults or violence in pretrial facilities, so now they're separated. And this happens in the courts, in the precincts, and also detention centers. And also there's a sealing provision that doesn't just apply to young people, but after 10 years, certain convictions can be sealed and removed from the record. That way a person can have opportunities to experience life without the stigma of a criminal conviction. And there are a lot more nuances within the law, but those are some of the general highlights.
So, Judge, I know that you currently work with in the drug part of the Supreme Court, but I know before then you spent a lot of time in the youth part. So can you elaborate a little bit on what you've seen and kind of give a little bit of color to what Rasheim was just talking about?
Rasheim was talking about the fact that you have to have the parents' involvement. Mm-hmm. When the young people came before me as a Supreme Court and they're charged with various offenses, you name the offense, from robbery, rape, homicide, attempted homicide, burglaries, assaults, you name the crime, I saw it in the youth part. What the end goal was in the youth part, you come before the court, and on the first appearance, when they're going through their arraignment process, I would ask the person, state your name and your age. They are looked at as a human being, and I asked them, do you have family in the audience? Yes, who's here? The family members sit right behind the defendant's bench in the audience, obviously, and I have the family members state, I am Joe Smith, the father of the defendant. I am Jane Smith, the mother. I am Tamika Smith, the sister. So everyone is involved. So I want everyone to understand, number one, what the child is being charged with. Number two, that there's involvement, so I can release that person assured that they're going to have someone to go home to. If they are fighting the case, they believe they are not guilty of the case, they should go to trial in the case. But if they believe that this is a case that they are guilty of and they want to plead guilty early on, I have them take a plea. I will defer sentence until maybe 12 months to 24 months later, at which point in time, my goal is to give them what's called youthful offender adjudication, YO adjudication. What does that mean? That means at the end of the day, I tell them, your case is sealed. You're giving, and the judge have to give the determination as to why, and justify why we're giving youthful offender adjudication. Why should their records be sealed as a YO? Guess what? If you commit another crime, you cannot get YO adjudication anymore. It's a one-shot deal.
Okay.
Similarly to the drug treatment part, if someone is accused of selling drugs or possessing a certain amount of drugs, and they determine to have a need for rehabilitation, a need to get off the drugs, a need for therapeutic treatment, and they meet those qualifications, I will dismiss their case. That shows, instead of incarcerating everybody, it's giving them an opportunity to rehabilitate themselves. For the youth, same ability to go through programs that will better themselves so they don't come back through the criminal justice system.
And so that you described, your process, and it shows that, you're very interested in making sure that youth have an opportunity. But can you talk a little bit more about how crimes committed by young people are typically handled?
Well, crimes, again, with the new legislation, if someone is 16 years old, for example, and they commit a robbery offense, there's certain various degrees of robbery. You have violent robberies, you have nonviolent robberies, and that is typical case that I would see in the youth part. A lot of the robberies, or so-called nonviolent robberies, that would stay in the youth part prior to the new legislation. Now, they're presumed to go to family court to be handled instead of a youthful offender, but as a juvenile delinquent if it goes to family court. However, if you have a case involving a shooting, a rape 1, those are the cases that require the DA's office consent in order to send that to family court, because they are the violent crimes with firearms, sexual offenses. Those are the crimes, even you might be 16-year-old, you might be 17-year-olds, or even 18-year-olds. Those crimes typically will stay in Supreme Court under the youth part as opposed to going to family court.
So that means for those cases, there's some type of prosecutorial discretion as to whether the actual circumstances of the case merit going to something like the youth court, but if not, they'll just stay in the Supreme Court. Is that correct?
Youth part is part of the Supreme Court.
Right. So
Family court.
If that happens, then it'll be going to the family court.
Correct.
If not, it'll be staying with the youth court, which is part of the Supreme Court.
Correct.
Right. And that was actually a terrific setup for Rasheim, especially when we're talking about family court. Sometimes people don't know exactly what the difference is between family court and the youth part in the New York State Supreme Court system. So can you tell us a little bit more about the family court and why it may be advantageous to some folks to have their cases in family court as opposed to the youth part?
Sure. So the big picture is the end game. In family court, the dispositions are called dispositions. They're not called sentences. There's a presumption against detention, and the goal is to rehabilitate the young person in family court. And the court considers the needs and the best interests of the respondent. And the person accused of the crime, the young person, is actually called a respondent. The attorney for that person is called the attorney for the child. There are dispositions, there's probation involved, there's mental health treatment involved, there's programming involved. It's much more restorative, it's much more holistic. The adult system, on the other hand, can be much more punitive. So, like Judge Mitchell mentioned, on those threshold crimes like a robbery where prosecutorial discretion comes into effect, a person could be facing state prison time. In the family court, there's a presumption against detention, and the court is looking for the least restrictive alternative so that it does account for the needs of the public safety, but also the needs and the best interests of the respondent. takes into account safety, but the idea is to have the young person in the community to be a productive member of society. So those outcomes are very different. Some people find through experience that some young people who go to jail with adults end up becoming more hardened. Their issues are aggravated. They haven't been restored or rehabilitated. In fact, they become worse. And this happens with solitary confinement, with some of the aggression, and they don't receive the services they need. So there are a lot of gray areas where prosecutors can use discretion and where there are sentencing guidelines in Supreme Court. So if some person is convicted of a violent robbery or a violent felony offense, sometimes the judge doesn't have the discretion to give them a lower sentence. Sometimes state prison is required.
Unless. If I interject.
Unless.
What I try to do is, even though it's a violent crime, unless I can find mitigating circumstances that allow youthful offender adjudication. You can get, as I've done, and it's in the papers, a young man was involved in a homicide, and I gave him youthful offender adjudication, but I sentenced him the maximum sentence under the law, 1 1/3 to 4 years incarceration. That's the maximum sentence, but guess what? When he gets out of jail, he will not have a criminal record because I found mitigation in the matter in which that crime was committed. So the point of the youth part is similar to the family court, in which we're trying to not only rehabilitate these young people, but to get them on the right track so they won't have a criminal record, but while sentence is pending, they go through the programs. They go through the cases program. They go through the Fortune Society. They go through various programs that are geared to making sure that their needs are met. They go to the homes of these individuals to make sure that they are actively securing employment, the families securing employment. It's almost like the social aspect of it is complete while the case is pending. But I try, as do all judges in the youth part, because as Rasheim indicated, their minds are still developing.
Right.
And they do not understand the ramifications of what they do. So even though some of these crimes may have occurred, they might be violent crimes, the prosecutors might want them to spend 15 to 20 years in jail for all these offenses, we still try to find a way similar to what family court is in the youth part. And that becomes very difficult for us judges because we have to look at public safety, but also in the best interest of these young people, because they're going to come out of the jail and they need to be at least somewhat rehabilitated and not sent to jail for a substantial period of time.
So one thing you mentioned is, mitigating circumstances, and certainly we don't want you to talk about any specific case, but when somebody when they do have to go through the youth part as opposed to being in family court, what are some of those mitigating circumstances that could at least be a part of the analysis when determining what the appropriate result is for that person?
Well, under the law, some of the mitigation circumstances we have to look at is, was he the only participant in the crime? Well, 2 people involved in the robbery, okay. Did the person in front of me pull out the gun and fire the shot, or was he with someone as a lookout? He was an actual person who did it. It's a mitigating circumstance that I can take into effect in justifying giving that person youthful offender adjudication. Was it a violent crime in which someone was seriously injured? Not only that, but when it comes down to the person and have justification, for me to give justification to have him released from jail, is he a danger to community? Those factors are separate and apart from the manner in which the crime was committed. I also take into consideration, and you look at what's called a pre-pleading memorandum the defense attorneys provide, it's very sad. Some of these individuals have been sexually abused as young children. They've seen people murdered in front of their face as a young child. They've been shot themselves, or they've been injured themselves, and this is all before they reach the age of 10 to 15 years old. So their life is almost a predisposition to crime because that's all they know. Their parents left them, they go from shelter to shelter, and I get a nice oversight as to who this person is. When they come before me with a robbery in the first degree, that second type of crime, and they're only 17 or 16 years old, there is a background. And I have to take that into consideration as to how I'm going to treat that person. Not just the manner in which that crime was committed, but I have to look at their background. That's very important.
Judge Mitchell mentioned some important considerations. This happens in the youth part. So you have, let's say, a 16-year-old. There's a big distinction between nonviolent and violent cases. There's a presumption for nonviolent cases to be removed to family court. The bigger issue is the violent robberies, for example, the robbery in the first degree. When the accused has a gun, a loaded gun, and let's say it's used, someone is shot. And it's very hard for a prosecutorial agency to justify not charging that more seriously because someone was injured. But the way Raise the Age was written, the courts must consider whether the person was armed with a weapon, a deadly weapon, usually a gun, whether the injuries were significant, whether it was a sexual offense, and whether there were extraordinary circumstances that would warrant keeping that case in Supreme Court. So there's a lot of litigation around these issues, but it is this sort of balancing and considering public safety and also the propensity possibly of this person. Would they go out and reoffend or injure someone seriously? Because this is where discretion is at play, and a lot of people do not want to be accountable for allowing someone to go out and commit further crimes if they have the opportunity to intervene much sooner.
Yeah, so one of the things we're hearing a lot about is, whether someone should be going to family court, whether they should be in the youth court. And I think, and correct me if I'm wrong, the whole idea here is trying to figure out ways to reduce the likelihood of folks being incarcerated, especially in adult circumstances, so that there's a less likelihood of recidivism. What are some of the ways that, in addition to just not being incarcerated or having some of these chances, that people are being rehabilitated? I mean, you mentioned a couple of things about some of the social aspects of it. Maybe some of the things I know you, Judge, may say you have to do A, B, and C, but what are some of the things, except for being incarcerated, that people are being asked to do so that they can start to rehabilitate their lives?
When I deferred the sentence, when I was the youth part judge, deferred sentence, you are to stay in school. These are some of the parameters. You are to write an essay to this court about the crime that you committed and why it was a crime that you should not commit. You are to indicate in that essay how it affected not only you, but the other person who you victimized. You are also have a curfew. Sometimes I set a curfew at the time of arraignment. You have to be home by 6 p.m. Monday through Friday. I might extend it to 7 o'clock. And I say, listen, everybody knows the weather's getting nice. You want to go out and hang out. But guess what? You're charged with a robbery in the first degree. You're in Supreme Court now. I'm going to set the parameters. The DA wants you incarcerated, but I'm not going to incarcerate you. I'm going to hand over the keys as a warden to your mother. When I set the parameters and they violate the curfew, I might say, listen, you have to spend a night in jail. Why? Because you violated these terms. And I don't like doing it, but sometimes the wake-up call, just have them incarcerated overnight, so the next time they see the horrors of going not to prison, to Rikers Island anymore, to go to detention centers in New York State for the kids their same age. But that gives them the incentive not to violate the terms of the curfew, does not violate the terms of what I tell them to do when it comes down to not only essay writing, but there's programs they have to be part of. And that gives them almost a probation. It's a probationary period before a sentence. So they follow all the rules and regulations, not getting rearrested. They almost followed the probationary period, even though I didn't put them on probation at the end of the day when the case is ultimately resolved by a sentence imposed by the court.
Yeah. And can you talk about maybe some of the successes of the way you're implementing these laws?
Well, the success is not when I'm implementing these laws, is how the youth appear and how they complete it. And it's very proud of situation where they complete it. I give them youthful offender treatment. They've come back to the court and thank me for just seeing them on the street. Judge Mitchell, I understand what happened, and they're very congratulatory to not only to me, but I congratulate them. I congratulate the parents. And I don't see them again. Sometimes, unfortunately, going from the youth part to the drug treatment part, I have a case in which a young man was in the youth part, and I might see him again. So there are successes and there's failures. When it comes down to the drug treatment part, when the time is for sentence and they complete all the goals, I give them a round of applause, everyone claps. I go down, I get off the bench, I hand them their final certificate indicating they can complete the drug treatment portion that's required, and they graduate it. It's almost like a graduation, and they are very happy to hear that. So it's not about the laws that is changing, it's about how the people act, how they act when they complete, and how their esteem is so lifted, and that causes other people in the audience to see that. And I said, listen, you see this young man, he just completed, his case will be dismissed, he will be able to secure housing, he won't have a criminal record, he will be able to get loans, he'll be able to get a car, he'll be able to, all these good things that you are missing out if you have a criminal record. But he does not. Ladies and gentlemen, you see what happened, you can follow the footsteps, and that motivates more and more people who are in this court.
Yeah, that's great.
So one other thing that was brought up earlier is about having your record sealed or or the disposition sealed. And I know we touched on it a little bit earlier, but I want to make sure that our viewers really get this point. So when somebody is before you, whether it's in the youth part or whether it's in the family court, and they're getting a disposition, and their record is actually getting sealed, like how does that change now under raising the age versus maybe before raising the age?
Well, in family court, the records would seal upon the completion of the case. For youthful offender adjudications in Supreme Court, those records would seal anyway. But with raising the age, this is actually for anyone who 10 years removed from a sentence on a case and certain convictions with certain conditions can be sealed. The person has to make a motion to the court where they received their harshest sentence. And there are a lot of conditions, like for example, you can't have more than 2 convictions. Violent felonies cannot be sealed. Certain sexual felonies cannot be sealed. So there are conditions, but this applies to more than just the youth. This applies to people who would like to have their name cleared and to be able to move on in society without that stigma of a criminal conviction. So essentially, all of the information is available online, but they would have to go to the court where they had their highest conviction and have that, make a motion to have it removed. And some DA's offices will consent and allow this record to be sealed. So it's really a negotiation. They could probably retain an attorney or speak to an attorney about how this process works. But it's part of the progressive prosecutions where a lot of agencies are looking at criminal justice in a different way, saying, look, this person has already did their time, so to speak, so let's give them an opportunity to have a new lease on life.
So one of the cases that many of our viewers and frankly just a lot of people in New York are aware of is the Kalief Browder case, where there is an individual who was arrested for allegedly stealing a backpack and ended up being in jail waiting for a result in his crime for a very long time, I think over a year. Can you tell us a little bit about, now that raising the age has passed, what that looked like for him then, or someone in his circumstance, and what that would look like now today when it comes to being in the New York Supreme Court, or maybe the youth part portions, versus being in the family court?
Sure. Well, I can't speak to Kalief Browder directly because I didn't handle
Sure.
that case. But in general, when you think before raise the age, when a 16-year-old is arrested, and let's say they be sent to a court and see a judge, and they may be held in a holding pen with adults. They may, if they are put in on bail, there's a chance that they'll be housed with adults. At Rikers Island, there's a chance that they would be circulating around adults. So there's this idea that this young person who's 16, again, not fully developed, is being treated like adult, somehow punished like an adult, and without the structure and without the age-appropriate resources. So now with Raise the Age, lawmakers and prosecutors and corrections, the agencies are more aware of age-appropriate circumstances. So parents get notified of the arrest, parents need to be present for questioning, parents, and there's also this presumption against detention for certain cases. So this idea of we're gonna put you in jail is not the first resort, it's actually the last resort. Let's look at how we can have you in the community. Let's look at, if we want to place you, let's try to have you in a facility with people your age and have treatment and resources by people who are actually trained in dealing with young people who possibly have mental health issues, who possibly need more attention than they would get in Rikers Island, for example. So I think now there's more age-sensitive treatment and there's presumption against detention. It's a part of like a bigger look at criminal justice and criminal justice reform.
And the number of the youth that were in Rikers Island has been significantly reduced. And matter of fact, they're no longer in Rikers Island. Under new legislation, state institutions have secure facilities. If the person is supposed to be detained, it will not be Rikers Island. It will be in a secure detention facility with individuals their age, no longer with adults. So for example, if I have to handle a U-Part case, no adults can go through the court system in that part for that particular day, because the U-Part is separate and apart from other cases or other courtrooms, so they cannot commingle adults and youth. Even if the adults have cases, and it won't be in the same part, the U-Part, because it's separate and distinct. And that's the legislation, just to tag off what Rasheim said, they don't want to have any type of commingling between the adults and the youth. So right now, if you're 16 years old and you are detained, it's presumption against detention, but let's say it's a homicide. 9 times out of 10, there will be some type of detention, but that person will not be in a facility with adults. They will be in a state secure facility with children their age.
Can you talk more about some of the, the phases in terms of how this law is being rolled out and implemented?
The first phase, when I was a youth part judge, 16-year-olds were before the court. Now, after October 1st, 2018, it goes up to 17-year-olds, okay? October 1st, 2019, it'll be up to 18-year-olds. So initially, when I was doing youth part cases, I was dealing with cases involving 16-year-olds who were charged with the robberies. If they're arrested now, they're going to be zoomed to go to family court. Come 2019, it's going to be presumption that those who are under the age of 17 will not be charged with any crimes as adults. So there are different phases. We, being New York State and North Carolina, I believe, we're the only 2 states, the last 2 states,
right,
to have the age of responsibility risen. So we are behind the ball, and instead of having everyone brought up to the 18-year-old limit at one time, the government, the New York State government, chose to do it in phases. So the first phase we're in now is 17-year-olds up to 17. Next phase up to 18, and they may say beyond, it might go up to 21, but may. But right now, we definitely have in effect 17-year-olds now, then 18-year-olds 2019.
Well, this has been another great discussion. I want to thank our guests for raising the bar with the MBBA, Judge Mitchell, as well as Rasheim Donaldson.
And I'm Adeola Adejobi. If you have any suggestions on how to tackle this issue, or you have any general questions and comments regarding tonight's show, you can email us at info@mbba.nyc.org or visit the website, which is mbbanyc.org. Thanks so much for watching Raising the Bar on the Manhattan Neighborhood Network.